Okay, perfect. Okay, well, we will go ahead and get started. I know it's late and I know everyone's probably tired after a long day and it's Tuesday. So we'll go ahead and get started and jump right in. My name's Trish. I'm an estate planning attorney. I'm an Athens native and a mom. And I started Arch Legacy Firm 2 years ago at the beginning of 2020. So of course, right before COVID. And thank you all so much for joining me. And we'll go ahead and jump right in. So if you hang around, I promise I will make this presentation as quick as possible. It should only take about 30 minutes. We will offer a couple bonuses at the end of the webinar. One's going to be a complimentary virtual one-on-one meeting with me to really discuss your specific goals and your family, and for me to better explain the different options. And then also, if you do choose to plan with me, there will be a discount towards your planning. So hang out to the end and there will be more information about that. So let's go ahead and jump right in. You're in the right place if, number one, you have kids, but number two, if you have someone or something that you care about and want to protect. You don't know who to name for guardians. A lot of the times I get that a lot, that people haven't named guardians because they don't know who to name. It's definitely a very tricky question. It's hard to think about anyone raising our kids other than us. You're nervous about meeting with an attorney. I know attorneys can be intimidating oftentimes, but I promise I'm not that type of attorney. And then also you just don't know where to start. It's a process, it's a legal process. And frankly, it's not something that we often sit around the dinner table talking about, estate planning and naming guardians and what happens if we pass away. So people don't really know how to start the process or how to even begin to make sure that their kids are taken care of in case something happens to them. So you're in the right place if any of those apply to you. The reality is that estate planning is not really about us at all. It's really more about the people that we love. It's about protecting our kids, our loved ones, making it as easy as possible for them and helping them avoid court and conflict. And really at the end of the day, our loved ones will know whether we lived up to the promise of I took care of it. So a little bit about me. Like I mentioned, I'm an Athens native, born and raised. Went to Timothy, Clark Middle, Clark Central, and then Georgia. So literally I was off Baxter Street for quite a number of years. I escaped for a little bit, went to Emory Law School, and then came back to raise my family. I have a dog, Woody, and a cat, Whiskey. And then I have one little boy, Max, who is about to turn 3. He's definitely a handful. I actually work with my sister. She is my paralegal. We haven't killed each other yet, so we're doing pretty good. And she has two boys, also boys, who are 14 and 11 and are very close. They live like a minute away from me, so I kind of consider them my oldest kids. My mom and my dad literally live a half-mile away. My brother's the only one that has escaped Athens and lives in Denver and loves it, I'm pretty sure. So like I mentioned, I went to UGA, poli-sci major, before going to Emory Law School in Atlanta. When I graduated Emory Law School, I worked for the Medical Association of Georgia, representing doctors for several years, and then decided to move back to Athens and worked as up counsel for a firm in Augusta while actually owning an all-women's gym off of Baxter Street, of course, because why would it be anywhere other than Baxter Street? I promise I'm not opening a law firm on Baxter, so yeah, and then when I had my son in 2019, as a lot of y'all probably know, having a kid just totally changes your mindset. So I decided to dive really back into estate planning full time and convince my sister to come on board with me. So we are both UGA grads, and actually we're both poli-sci majors. And so I'm really very fortunate to have her to work with. And frankly, my clients are as well, because she is meticulous in her drafting and really puts out a lot of effort to making sure that all of the plans we draft for our clients are perfect. So why did I start with estate planning? My son, first and foremost. When I had him, I knew that I needed to do this. I needed to name guardians. And when I started looking around, I really realized that everything, really nothing had changed in like 50 years with estate planning. It was all still fill in the blank wills, name a guardian. And I was like, there's got to be something more to it. You're protecting our babies than that. So I kind of started diving in with that. I also got to see the epic failure of an estate plan when my grandfather passed away, technically my step grandfather. So it was a blended family situation. And my grandmother had been a real estate investor here in Athens. So it was a pretty complicated estate. And my dad was in court and conflict for 4 years. And in fact, this was 6 years ago, and the executor just contacted him a week ago to touch base about some more loose ends. So it's actually still ongoing, which is just insane. I imagine the attorney's bills associated with that. And then also my dad. My dad just had a simple will, and he was single at the time, divorced, and a smoker, and over 60. And he just had a simple will. He went to a very well-known attorney here in Athens. They didn't do a power of attorney, healthcare power of attorney, advanced healthcare directive, nothing. Just a simple will leaving his estate to the three of us, me, my sister, my brother. And that is basically what the law would do. So in reality, they charged him for the law. And watching my grandmother's estate, and they had an estate plan. They had a very expensive estate plan. And then with my dad's will, I was like, this has got to be malpractice. These attorneys cannot be charging for something that is so set up for failure. But in reality, I realized that it's very common practice. So I knew that when I started my firm, I wanted to do something different. Number one, I didn't want to focus on only individuals that had millions of dollars. I wanted to focus on families like mine, young families. I wanted to make sure that kids are protected and really connect with my clients on a much more personal level and create plans that fit their goals and that were very comprehensive. So that's kind of how I came to start Arch Legacy. So, if you're here, I'm going to assume that the answer to this question is probably yes. Do you have people that you love and want to protect from court and conflict? This is kids, spouses, siblings, family members. What we don't realize is that if we don't name guardians, a judge gets to decide who the guardians of our kids are. And this causes a lot of conflict because family members will be fighting each other for your kids, or even not wanting them, heaven forbid. But it causes a lot of conflict. And so if you have anybody you love, including yourself, because estate planning does include aspects of protecting yourself as well, it is really important. So what we're going to learn today is how estate planning can affect your family. And to do this, we're going to look at just your average Joe Schmo family, the Smith family. And we're going to run through a scenario of some really sad circumstances. Trigger warning. Obviously, this is estate planning, so it's not the happiest of subjects in the world. So it's a little bit morbid, but we're going to run through the Smith family. And we're going to play out some different scenarios with some different types of estate planning just to get a better idea of what estate planning does, what it can accomplish, and what it doesn't. So first, we're going to meet the Smith family. We've got John, Samantha, John Jr., and then little baby Allison. And they're just your average family. So mom and dad dad's flying out of the country for work. Mom has a meeting, so they call the babysitter. Longtime babysitter. Kids are excited. They love her. They're ready to play and have a good time. Parents obviously trust her. She's been babysitting them since John Jr. was itty bitty. So Samantha's on her way to work to the meeting when she gets an email saying, hey, meeting's been postponed. So she decides to go hit up the gym in her spare time. So she locks her purse into her locker, like a lot of us do, hops on the treadmill, and unfortunately has an aneurysm and passes away. Now, her purse is locked in the locker room. She doesn't come home. The babysitter's frantically calling, can't get a hold of her. What does the babysitter do? So, of course, this is an extreme scenario, but if you really think about it, this is something that could happen. If you're out on a date night and you get in an accident, we don't like to think about this stuff happening, but it is very relevant and it can definitely happen. So babysitter's calling, no estate planning. What does the babysitter do? Babysitter calls the police because she doesn't know what else to do. Police have no other option but to put the children in protective custody until the dad can get home to be with them. So this is not anybody's ideal solution. No one wants your kids to go to protective custody, child custody. You want them to be with someone that you trust, that they feel comfortable with, that they love. They're already confused, they're already traumatized, they don't know where mommy is. So this is, in my opinion, one of the worst case scenarios. We don't want our kids to go into protective custody. We want to make sure that there's a better option. So what would happen if they had a simple estate plan like a will and permanent guardians? Well, unfortunately, most likely the exact same scenario would take place. Police would come, babysitter would call them, kids would be taken into protective custody until the dad could get home, because permanent guardians and wills don't really have anything to do with this type of scenario. And this is one of the things that I realized was missing in a traditional estate plan. This is one of the things that I knew I wanted to do better for my clients with minor children. So what we do is we name emergency guardians as well as permanent guardians. And emergency guardians are friends or family who live very nearby, who can step in and keep your kids legally in the event of emergency. So these are neighbors, close friends. If you have family that lives close by, basically these are people that you trust, maybe not to be the kids' permanent guardians, but certainly to keep them for a few hours or even a couple of days until your permanent guardians or until a family member can get there. But they're very important because they will have the legal authorization to keep your kids, and they will actually have that on their person so that in the event of emergency, your babysitter has instructions, which we actually provide, laminated instructions with our kids protection plans, and they will know who to call and who to get there before they ever call the police if the parents don't show up or if they can't get a hold of them. The fact is that guardianship is equally about what happens in an emergency as it is about who raises your kids if you can't. So there's really two types of guardianship. It's emergency guardianship and permanent guardianship. So what would happen if they had advanced estate planning like we've been talking about? Well, babysitter has the instructions, calls the emergency guardian. Emergency guardian is someone the kids know and trust. Emergency guardian can stay with them until the dad is able to get home and they can mourn mom together. So still a very sad story, but with a little bit of a more comfortable twist to it. No more child custody, no more police. Instead, close family friends that keep the kids safe until dad can get home and be reunited with them. So now, because again, this is estate planning, it's only going to get worse. So John, in the interim, decides to take out a life insurance policy before he gets in a car crash and also, unfortunately, passes away. So, naming guardians. When he took out his life insurance policy, he did name guardians. He did a will, he named permanent guardians. And here are some things that he considered when he named his permanent guardians: values, spiritual beliefs, financial approaches, location, similar child rearing ideologies, and access to loved ones. A lot of people think that it's almost like a given that it has to be one of our siblings or it has to be our parents or someone that's closely related to us. And while a lot of the times that is who we choose, it doesn't have to be that way. You can legally name any person you want to name to be your guardian for your children. So it could be a close friend, it could be a cousin, it could be anybody who shares these values that you find important so that it meets your criteria. What is your criteria for how you want your child raised if you're not able to do it yourself? What would be the most similar circumstances to mom and dad being there? So these are all some things to consider when you are thinking about who you would want to name as your permanent guardian. What are their values? What are their discipline ideologies? What are they religious? Are they the same religion? Financial approaches. Do you want your guardian to also be in charge of your children's inheritance, or do you want that to be a separate person? Location. A lot of people would really want their kids to stay in the same place. So location can be a big one for a lot of people. And then also just making sure that they remain around other loved ones like grandparents and things like that. A lot of people will name their parents as the first guardian. And we do a subsequent list of guardians because of course we always plan for the worst case scenario and hope for the best. So if people name their parents as the first choice, I often try and encourage them to name someone more around their age for a backup, to make sure that, in case their parents are no longer able to when it comes down to it. So question, and I am going to run a poll now, and I'd love to hear y'all's responses to this. Do you know who you would name as legal guardians for your children if you had to name them today? So I'm going to go ahead and launch this poll. So tell me, do you know who you would name as guardians if you had to name guardians for your children? So getting a few maybes, a few yeses, another maybe. I got a Jesus take the wheel. Yes, maybe. Awesome. So no, so that's great. And one of the things that I really like to make sure that my clients know is that even if you know who you want to name as your guardians, you definitely want to make sure that you have that discussion with them as well, because heaven forbid you name someone as guardians and they're kind of blindsided if anything happens to you. So thank you all for participating in that. That's positive. Yeses, maybes, and then only one Jesus take the wheel. So let's hop back into it. And I see that there's a chat comment, and I will get to that at the end of the presentation. So if you have any questions, we will get to questions. So kids move in with their guardians. They start to readjust, get back to normal life. But the question now is, what happens to that life insurance? What happens to any assets that the family has? How do these kids inherit? So result one, kids inherit immediately. This is typically with a will, a simple will, or no estate plan at all. So if they inherit immediately, the really important thing to remember is that minor children cannot inherit funds. If you take nothing else away from this, remember that minor children cannot inherit. So if you name them as the contingent beneficiary of a life insurance policy or anything like that, and something happens to both you and your spouse, then please know that they cannot inherit this money. So instead, all of this money pours into the probate court. Here, I'll rerun the skit here. So the judge gets to decide who the financial conservator is, and then once the kids turn 18, they inherit all of their money in lump sum check, whatever's left over. And y'all, I don't know about what would have happened to you if you had inherited a bulk sum of money at 18, but I know what would have happened to me, and it would not have been extremely wisely invested, we'll put it that way. So here's John Jr. and Allison, and they have blown right through all of their inheritance on cars and whatnot that an 18-year-old would be attracted to. So what is probate? So I mentioned that all this money would be thrown into probate, but what is probate? So probate is the court supervised process for distributing assets after a person passes away, meaning that after you pass away, unless you jointly own all your assets with your spouse, including your house with rights of survivorship, which is rare. Most people don't own their house with rights of survivorship. Or if you literally have no assets, if you have any assets that are individually owned, then they will go through probate. And probate is a court process. And most likely your family would have to hire an attorney. And probate process takes anywhere in Georgia between 6 months to 2 years. It kind of depends on where you live. Athens usually averages around 9 to 12 months. Same goes with similarly sized towns. Atlanta is 2 years. Don't go through probate in Atlanta. That would be the absolute worst. But so probate is an open court process. So if there's going to be anybody contesting guardianship or where your assets are going or anything like that, they can do so and very easily. So what about a will? What does a will do? Does a will avoid probate? So actually, a will is just a legal directive that tells the judge how to distribute your assets. It does not avoid probate whatsoever. A will it says who you want as your executor, who do you want to manage the probate for you, how do you want your assets distributed, and who do you want as permanent guardians for your kids. So wills are extremely important documents, absolutely necessary, but they're not the end all be all, because wills don't avoid probate. So if your goal is to avoid probate, wills don't do it. However, if your goal is simply to name permanent guardians, wills are great. Wills do not control all of your assets either. Any beneficiary designated items like retirement accounts, life insurance policies, those are also not controlled by a will. So having a will equals probate. Wills are public. Once they're probated, anybody can see what's in your will. They're very easy to contest. It is a court-involved process, and typically probate attorneys do have to be involved. There's no distribution of your assets, including your house, until the probate is wrapped up, which, like I mentioned, can take 6 to 12 months, depending on where you live, 2 years if you're in Atlanta. And if you own properties in multiple states, there's going to be multiple probates in each state. And while Georgia is not the absolute worst probate state, Florida, on the other hand, is an awful probate state. And that is where my dad was actually in court and conflict. So highly don't recommend that. So next question, my last poll for the evening. Have you ever experienced the probate process with someone close to you? So I'm going to launch this. And have you ever experienced probate? So I've got one yes, lots of no's, and then one indirectly. So yeah, that's about right. It's even for simple, straightforward probates, even if it only takes 3 months, I've never heard someone say it was an enjoyable process. But again, it is there to make sure your assets get to who they belong to. So it is a good process. In the sense that it's going to make sure that your kids go to the guardians that you name, if you name them legally, and that your assets go to who you want. Now, if you don't have a will and everything goes through probate, the judge gets to make the decisions for you. So if you haven't named guardians, the judge gets to name them for you. And y'all, if you think it's hard to figure out who you want as guardians, imagine what some random judge who has no idea what your family's like, who they would pick for you. So definitely want to avoid that. So how do your kids inherit with a will? So like I mentioned, minor children cannot inherit money. So all assets would flow right into that probate court, and a judge would appoint a financial conservator. This could be anybody. It could be a professional. It could be a family member. It could be a guardian. It could be someone totally unrelated. So we really don't know who the judge is going to choose as your children's financial conservator. And for the record, the financial conservator usually takes a cut of the money. So while they're managing it, it could be anywhere between like 3 to 5% that they're taking as a cut for managing the money. So just know that as well. So when will the children receive their inheritance outright with no protections or guidance? Most likely at 18. Some wills do say 21, but honestly, that kind of depends on the situation, because sometimes that might not be possible. So it really totally depends, but most likely at 18. In a simple will, it will absolutely be 18. So let's talk about something better, a better option. Now, again, wills are very, very important documents, and a will might fit your family and your situation perfectly. But if you do have assets like a house or life insurance with minor kids, and you do want to maybe protect those from probate, there is a better option to do that. So result 2 is that the kids receive their inheritance in trust. So they receive their inheritance in trust, they avoid probate, the money's there under the guidance of a trustee until your kids reach certain ages. The money is used to put them through college, maybe help them put a down payment on a house, start their own families, and remember their parents as someone who really took care of the estate for them. Because y'all, I'm going to tell you right now, while it's amazing that you're here to take care of your own kids and your own family, remember that it's your parents' estate that's going to affect you the most directly. So I always try and tell people, in my generation, remember, we got to make sure our parents' estates are taken care of as well. So what is a living trust? A living trust is a probate avoidance tool, and it goes hand in hand with your will, but some people call it a will. a will substitute. But in reality, you still have a will, and wills are always very important. They are the most legal document that you have. But a living trust or revocable living trust goes above and beyond. And there is no probate. And if you have minor children, this can be extremely beneficial because all of those assets will just flow into your trust. So if something happened to you while they're still minors, you get to be very creative with how you would want them to inherit their funds. You want them to inherit in an asset protection trust. So if they ever get divorced, it's protected. Or do you want them to inherit it at ages and stages? You know, a third at 25, a third at 30, remainder at 30. 35. We can get so creative with living trust. So if your share of jointly owned assets goes into your trust, beneficiary beneficiary designations are updated to your trust. So like life insurance policies, retirement accounts, you typically name your spouse first and then the trust as the contingent beneficiary, just again, to make sure if something happens to both of y'all, that all of this flows right in there. And then all of your trust assets are immediately available for your loved ones. No probate, no delay, no court, no probate attorneys, no court fees. So what are some other considerations about estate planning? Now, when I said at the beginning that estate planning is not really about us, it's about our loved ones, that is 90% true, but there is 10% that is about us, and it's a really important part. What if we're incapacitated but still alive? So what if we need a power of attorney, someone that can manage our finances while we're incapacitated, or a healthcare power of attorney, someone that can make healthcare decisions for us if we're incapacitated? And what if we need end of life decisions? So a lot of people have very strong feelings about what would happen if they're hooked up to a ventilator and that's the only thing keeping them alive, and they have no hope of recovering. So these are very, very important things because these are things that affect us while we're still alive. And in order to make sure that the people we want making our healthcare decisions and the people that we want accessing our bank account, you have to have these documents in place. Also, I mentioned that if you have kids that are in college or older kids that are not married, these documents are also going to be very important for those kids, because while we can name guardians for our minor kids, and while we may think that some of our older kids probably still need guardians too, yes, they probably do. We can't name guardians for them. And once they turn 18, mamas, we don't have the ability to make decisions for them anymore. So if they're in college and get in an accident or anything like that, you can go rushing to the hospital, but they're not going to let you have access to the medical records or make medical decisions unless your kid is named you as healthcare power of attorney. So very, very, very important documents. When I was growing up, I guess back when I was in elementary school, there was the big Terry Schiavo case. Terry Schiavo hooked up on a ventilator. Husband wanted to let her pass. Naturally, parents did not. Huge court case. You would think the husband would automatically have the right to make these decisions, but because she didn't have a healthcare power of attorney, he did not. And so it went through court, and y'all, I mean, to this day, people still remember Terry Schiavo, which is huge. Like, it should never have been that big of an issue. It's a private family matter, not something that should have been dragged through the courts. So, lesson number 1. Our children are our most important assets. In any estate plan I do, my goal is to protect the kids. If they're minors, I want to comprehensively protect them. I want to do emergency guardians, permanent guardians, and do minor medical power of attorney. So if something happens to them, these people that you trust can get them medical help. So kids, if you have kids, you have assets, you have an estate, and your kids need to be protected. So even if you have nothing else, I have something for you too that will help. But we all know that at the end of the day, if we lost everything, but our kids were still healthy and safe, we would be okay. So our kids are our most important assets, and guardianship is equally about what happens in an emergency as it is about who raises our children in the long term. Lesson number 2, wills do not avoid probate. And probate is a long, public, and costly process, but they do name permanent guardians, and they are very important documents. So while wills do not avoid probate, they are very important. And if someone's not worried about probate, maybe they don't have that many assets, or maybe they just don't care that much about probate, then wills are perfectly great documents to make sure that your kids will go to who you need them to go to. Lesson number 3, a review of all of your assets must be a part of the estate planning conversation. So I didn't really go over this, but it's really, really important. When most people meet with an attorney, they might draft a perfectly fine will or trust, and you might sign it, and they might even explain what it does. But at the end of the day, they're probably not going to make sure that you move your assets into your trust if you do a trust, or that you keep an inventory of your assets. And y'all, this is so important, because if something happens to you, you're probably the only person who knows exactly what assets you have, even including your spouse. Even your spouse probably doesn't know how to access some of those credit cards or some of your bank accounts or something like that. So it's really important to keep an inventory of your assets and to work with an attorney who will help you do that. Because y'all, there is over $1 billion in the Georgia Unclaimed Properties Department. Seriously, Google it after this or tomorrow. It's late, but Google it, look it up. Over $1 billion in the Georgia Unclaimed Properties Department. And you can even type in your name and see if there's something that might belong to you. Or like if you have like a grandparent that's passed away or a parent, type in their name and see if something comes up. Because that's a lot of money. That's just sitting there, accruing interest for the government. So very, very important to keep an inventory of your assets to make that available. So how is my law firm different? I went on this huge spiel about how I wanted to do things differently than most traditional attorneys. So what did I do? How did I do things differently? Number 1, I don't just draft documents. That's not what my job is. My job is absolutely to give you an amazing, meticulous product that we can continue to update as the years move on, but it will not be a document only service. That is not what my goal is. And if that's what you're looking for, totally fine. I'm not the attorney for you. So I don't charge hourly fees. I like to create a very personal relationship with my clients, and slapping someone with a $250 bill for giving me a call to ask me a question, not the best way to do that. So no hourly fees, no knee-jerk response to problems. I get calls all the time. Help, my dad's in the hospital in a coma and he doesn't have a will and we don't know what to do. Well, I can't do that. We like to plan ahead. We want to make sure that all of these situations are planned for in advance. You won't just be a transaction to me. You'll be a lifetime client, and hopefully I will become someone that you can trust. And no document that I draft is a fits all document. It's no fill in the blank wills, no nothing like that. If you want to fill in the blank will, there are online services for that work absolutely great. Don't go waste money on an attorney, do it online. Just make sure you legally draft it afterwards. That's what's a good fit for your family. That is absolutely fine. So scratch all of that, take that off the table. I do things differently. Again, flat fee, very transparent pricing. You're going to know exactly what you're paying for. More than just documents, it's comprehensive, personalized planning that really make sure that you have that peace of mind, knowing that it's going to work. Again, it's creating a personal relationship so I can actually get to know your family and know what your goals are. And then again, it is a plan that is created specifically for you, not for somebody else, with the names, Control F, replace throughout the documents. And yes, attorneys do still do that. Don't even ask. They do though. I've seen it firsthand. So my promise is that anybody who plans with me, their estate plan will leave no stone unturned, and I will hopefully give them the peace of mind knowing that your loved ones and your assets are kept out of court and conflict, and that your kids are 100% protected. Again, I have a 3-year-old, almost 3-year-old. That's very near and dear to my heart. So what are my different plans? I talk about transparent pricing. So y'all, I'm going to get super transparent with y'all. For the family plan, this is the plan that maybe probate's not a big issue or you're not concerned about it. All of my plans are very comprehensive. So they're still going to include wills, healthcare directives, healthcare power of attorneys, financial power of attorneys, and that kids protection plan, which includes everything you will need. For an individual, it's $1,500. For a couple, it's $2,000. This is a flat rate. It includes a lifetime relationship with me, all the questions you could possibly ask, unlimited conversations. And then typically I will say we do half payment up front and half signing. So it is about a month apart. And we accept all forms of payment. So again, I want to be extra super transparent with my pricing. I know it's a big question that a lot of people have is how much will this cost to protect? In my opinion, way less than it would cost if you didn't plan. But I know that's hard for a lot of us in our, we look at our bank accounts, we're like, oh crap, how am I, so I get it. That's why I like to be extra transparent. So the family plan again is the will-based plan. It will 100% comprehensively protect your family from everything but probate. Probate will still happen. And your kids will still inherit, probably at 18 or 21 versus the more creative types of inheritances. So our trust plan, which includes that joint revocable living trust, and everything else is the same. Revocable living trust, which is basically just a bucket that holds all of your assets so that they don't have to go through probate if you pass away. Again, a lot of flexibility with how your kids inherit. So this plan includes everything, and then also us transferring your house into the trust. So we have to transfer everything from your name. So if it's Sally Smith, we're going to transfer it from Sally Smith to Sally Smith as trustee of the living trust. While you're still alive, living trust, still all your assets. You can still sell, refinance, buy, change, add, whatever you need to do. But it avoids probate and it makes sure that there's a lot of flexibility with your kids. So if this is the plan for you and your family, it starts at $3,000 for individual or $4,000 per couple. And for those prices, it does say start at, but it includes literally everything I just mentioned. There are just some extra added trust that some people choose to add on, but are absolutely not necessary. So again, want to be super transparent with all of this. Now, if you don't have any assets, but you do have kids and you really want to make sure they're protected and kept out of court custody, I have an option for you too, and it's free. It's not a will, so it doesn't have anything to do with your assets, but you can name permanent guardians. And it's at this link right here, archlegacyfirm.kidsprotectionplan.com. So I'm going to give you a second to write this down if you need to. archlegacyfirm.kidsprotectionplan.com. If you don't have any assets, but you do have kids and you want to make sure that your kids are protected, this is a free way to name permanent guardians. Now you have to 100% follow the instructions. They have to be witnessed and notarized. Typically banks can do that in order for them to be legal. And you want to make sure that the people you've named as guardians know about this document and maybe even have a copy of it. But it is a legal way to name guardians, and it's free if you don't have any assets. And really your kids are all you're concerned about at this time. So what is our process like? If you do choose to plan with me, we have an initial planning session where typically virtual, but it can be in person as well, where I meet with you and your spouse if you're married, and we go over your assets, your family. I learn more about you, and then we go into a little bit more detail about the difference between a will and a trust. Only so much that I can get into here in a 30-minute webinar. And then that way, if you decide to plan with me, you can make a really informed decision about what's best for your family and your goals. If you do decide, we'll pick your package that you want to go forward with, and we'll schedule a short design meeting. This is typically virtual as well. This is about a week out, and this is where we sit down and we just discuss who do you want to name as guardian, who do you want to name as power of attorney, healthcare power of attorney, and I give you a really helpful design cheat sheet ahead of time so that you and your spouse can sit down at night after the kids are in bed and kind of hash it out together. And if you drink alcohol, maybe with a glass of wine or something like that, because these are not easy decisions. From the design meeting, we schedule a signing ceremony about a month out. The signing meeting does have to be in person. It's where we sign, witness, notarize, go over all of your documents. I answer any questions, make sure you know exactly what you're signing. And at this point, all of your documents are 100% effective. Finally, the final meeting is called a binder delivery meeting. This is where we actually deliver your big binder to you. It's this really big, ostentatious green binder. This has estate planning on it. But we scan the documents into our system. We keep them in our secure database, as well as giving you all electronic and the originals. Again, make sure you know where everything is. And if you chose to do trust, we'll catch up on that and make sure that everything's proceeding as it needs to for that. So the biggest risk to your family is procrastination. Y'all, this is the easiest thing to push to the back burner because we don't like to think about it. And we all know that when we don't want to do something, we go clean or cook or do anything other than what we actually really need to do. So procrastination is a big deal. No matter what your plan may look like, whether it's a will-based, whether it's a trust, whether it's just naming guardians, my hope is that you act soon and make sure that your kids are protected. And to help kind of incentivize that, if you do want to do a will-based or a trust-based plan, my free gift to y'all is that there will be a $250 discount on your plan if you plan with me and if you book that initial planning session within the next 7 days. So if you plan with me and book your family wealth planning session within 7 days after this webinar, you will get a $250 discount. And y'all, I hope to get to talk to some of y'all and meet some of y'all and learn more about your family. And that first initial planning session is no obligation. So if you still choose not to work with me, totally fine. I understand it's really just an educational session, but it will be pretty short because y'all have already learned so much. So thank you so much. Thank you for joining me on this Wednesday night. Oh, it is Wednesday. I think I said Tuesday earlier. Sorry. Who knows? On this Wednesday night, I know it's late. I want y'all all to be able to hop in bed and chillax now that we've talked about such lovely morbid topics. But if you would like to schedule a family wealth planning session with me, you can do so at www.archlegacyfirm.com/family FWP-schedule. So I'm going to write this in the chat and I'm going to open it up and see if anyone has any questions. So if you have any questions, please feel free to write them in the chat. I'm happy to answer. But I'm going to go ahead and put this link here in case you do want to schedule an initial planning session with me. Also, if you'd like a consult first, I do offer free consults as well. And that's just archlegacyfirm.com/schedule. Or if you have any questions, please feel free to email me at trish@archlegacyfirm.com. Always happy to help. So I'll give it a second to see if anybody has any questions. Again, thank you all so much for joining me. I really appreciate y'all taking the time to hang out with me on your Wednesday night. And I hope to hear from some of y'all soon. And if nothing else, I hope you have a great rest of your week. So I'll hang in for just a couple more minutes. If anybody has any questions, please feel free to shoot them in the chat. So while I'm waiting, one of the things that a lot of people do ask is when they're naming all of these important people, what happens if there's any conflict between them and their spouse? And that is what I'm here for. So just know, don't let this cause any type of marriage divorce or marriage, huge argument or anything like that. We can work it out and we can figure it out. That is what I'm here for. I've had to walk some people off the ledge before. So don't worry about that. I know it's hard decisions. But looks like no one has any questions tonight. So I'm going to let y'all go. Again, thank you so much for joining me. If you do have questions, please feel free to email me. And again, hope to meet with some of y'all soon. Bye, y'all.